Come on up. Yeah. All right, Mr. Baker, you're before the court today for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish to have the public defender to represent you?
No, sir. I'm going to represent myself.
Buckle up, guys. Today we're going to witness yet another Florida courtroom moment, where a man walks in convinced that he can outsmart the system. Right from the start, the scene sets the tone. A stern judge and a defendant about to dive into sovereign citizen territory. It feels calm for now, but trust me, this introduction is a calm before the storm, and things are about to spiral fast in front of the bench.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yeah. All right, guys, the judge wastes no time laying it all out. Charge after charge is read aloud, and with each count, the stakes climb higher. By the time the judge adds it up, this man is staring down the possibility of 30 years behind bars. And yet, instead of grasping the gravity, he calmly says he'll represent himself. It's the kind of decision that makes you stop and wonder if he even realizes how serious this really is.
If you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business.
All right. What kind of business?
A cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to make this decision?
No.
Here's where the judge tries to make sure the defendant truly understands what he's signing up for. Questions about education, sobriety, even mental health get thrown his way. It's a standard process, but the undertone is clear. The judge is spelling out that this is no game. Despite every warning, the man insists on moving forward alone, as if his 9th grade education and sheer confidence can stand up against decades of courtroom experience.
You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir. I
You
got
have copies for the state.
Yes, I do.
Now things take a bizarre turn. Instead of simply entering a plea, the defendant starts filing strange motions and presents a so-called bond paperwork that he believes will magically release him from jail. The judge, clearly unimpressed, shuts it down. This is classic sovereign citizen behavior. Thinking obscure documents can override the law. It's a bold move, but it only digs a hole deeper as the judge's patience begins to wear thin.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk. The declaratory
Anything you
judgment-
file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess
I
up.
understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today.
This is the breaking point. The defendant insists he's a private citizen, trying to dodge the sovereign citizen label, but the judge isn't buying it. Words keep flying. The judge demands silence, and when the interruptions don't stop, he orders deputies to remove him from the courtroom. It's raw, unfiltered courtroom tension. Watching a man who thought he'd play lawyer get physically escorted out after pushing the judge too far.
I filed my eligible obligation.
What are you talking about?
Sir,
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December. When's that motion day in December? December 19th at 9 o'clock. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private.
Finally, the judge makes official, declaring the defendant incompetent to represent himself. He strips away the man's self-representation rights and appoints a public defender. It's the ultimate reality check. The court is a stage for theatrics, and the law won't bend to nonsense. With a new date set, the case isn't over. But one thing is certain, this defendant won't be calling the shots anymore. If you enjoyed this video, hit the like button, leave a comment, and subscribe with notifications on. And we'll see you in the next video.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9 o'clock.
It's no problem.
That's enough. I don't want to hear another word.
Okay. I'd like to also.
I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him before he gets in any more trouble.